here it is, right? The call for privacy rights, right? The quote, recent inventions in business methods call attention to the next step which must be taken for the protection of the person, right? And you say, wow, that's a great quote. Who said that? When did they say that? Well, you might be surprised to learn that this was stated in 1890 in the Harvard Law Review article entitled The Right to Privacy. And it was written by two very bright young men who graduated first and second in their law school class at Harvard Law School, and the gentleman who graduated first, Mr. Brandeis, Justice Brandeis, went on to be a brilliant Supreme Court justice. But by this one article in the Harvard Law Review, they created what today we probably take for granted as the right to privacy. And the point here, this seminal article, was that it was not created by Congress, right? It was not created in some other way. With this article, these two gentlemen created what we're dealing with. And if you go read the article, which is, it's not that long of an article, from 130 years ago, it is amazingly prophetic for the issues that we are still dealing with today, including facial recognition issues. It is a fun read if you have the chance. So here's my disclaimer, which says, hey, that document's not legal advice. I'm not giving legal advice. And the fact that I'm up here and talking, right, I'm not your attorney. I have to say all those things. That's what that says. So, okay, roadmap. So what are we doing? The problem, we're going to go through this timeline of events to sort of state the problem. We're going to talk about the U.S. solution, and then we're going to talk about the EU solution, right, the European Union, which, as I say, sort of tongue-in-cheek, by the way, is coming to a theater near you. This is what you're going to feel like, right, like drinking from a fire hose, drinking from a fire hydrant. So that's my warning. Here we go. Right? So here it is, right? Target, right? Hack, 2013, 110 million records, right? Can we keep networks secure, right? Home Depot, right? 56 million records. Can we keep networks secure, right? Sony, right? Hacked, right? Hacked. Yahoo, right? 1.6 billion records, maybe impacting 3 billion records, right? Massive potential for identity theft, right? And most recently, or at least the large one most recently, right, Equifax, 145 million records stolen, massive potential. I have at the bottom of this slide, there's a link there. It's a very interesting website. It shows you with bubble charts and a timeline all the data breaches that have happened, like the size of the bubbles or the sizes of the data breaches and in time. And it's just interesting to look at that to see the frequency and size of the data breaches over time. So what are the results here? Well, this is not very good for consumers, right? You can go buy these records on the dark web. New York Times reports that, you know, this data is for sale on the dark web. Security Week, here's an interesting one. 1.4 billion clear text credentials, right? So these are not encrypted records, right? This is, you know, rayario@gmail, my password, right? It's there, all in clear text, was never encrypted, right? And you can buy these things on the dark web. You know, they say $1, but a lot of them are a lot cheaper than that. So, and it's not good for management, right? So, you know, Target CEO, right, resigned, right? Home Depot retired, right? Amy Pascal said she was fired, you know, because of the state-sponsored hack, you know, into Sony, right? Home Depot, 85 million in, and Equifax CEO, right, Richard Smith, he's resigned, right? Who knows how much that's going to cost him, right? If you look at the 1.4 billion clear text credential passwords, the one I was referencing, this is interesting. This was done by 4IQ. The top 40 most common passwords, right? Very interesting. Number 1, 1, 2, 3, 4, 5, 6, right? Number 2, 1, 2, 3, 4, 5, 6, 7, 8, 9, right? A lot of people, you know, password is it, right? A lot of 5, 5s and 7, 7s, the last row on the keyboard, right? And the interesting one, number 14, if you look at it, says, I love you, which, you know, 14th, that's Valentine's Day, so get that. All right, so here we go. Don't forget about the small breaches. Of course, these large breaches, you know, make the news, but it's the smaller hacks. Business Wire, Accenture survey from last year, and they just had this conference last week, so I don't know what they said last week, but last year they said 1 in 4 consumers have had their personal medical information stolen from an IT system, right? We have these other small breaches, the phishing, right, that's going on, right? Are you practicing in your companies or with your clients, you know, to be on the guard for phishing attempts, right? So why is all this happening? Well, we have more data online, hackers becoming more sophisticated, some companies not taking security seriously, all companies are on a budget, right? So, and maybe it's not even possible to protect it all, right? Why is security hard? Well, just look at the Internet of Things, right? How can we possibly secure billions and billions and billions of devices, right? This is a report, I don't expect you to read it up there, but maybe in your, but the main sentence I want you to look at is about halfway down from a security and privacy perspective. This is 3 years ago, right? This is the FTC, this is a very influential report. The predicted pervasive introduction of sensors and devices into currently intimate spaces, such as the home, the car, and with wearables and ingestibles, even in the body, poses particular challenges, right? So this is the FTC trying to get Congress's attention, right? And here they go. They are begging Congress, please, we recommend that Congress enact broad-based, as opposed to even Internet of the Things specific legislation, right? And at the bottom I highlight, it's about choices, about data collection and use practices. So just sort of keep, put a pin in that as we go forward. Why is security hard, right? There are zero-day markets out there, right, where you can go buy zero-day exploits, right? They exist. So what would happen? We have these zero-day marketplaces. Is that good or bad? I don't know. We could debate that. But what if the government developed zero-day exploits? What if they developed a lot of them and they packaged them into field-usable tools for use in state-sponsored hacking and spying, right? What if those tools became public? What do you think would happen, right? Well, it did happen, right? So this is the NSA issue. It was rumored to be called the Equation Group, which was NSA, was hacked in 2016. So now all of these zero-day exploits that our government created are out there that the hackers are all using, right, to get to us, right? So is this seriously? Yeah, this is really serious, right? Here's the article from the New York Times. Security breach, spilled secrets have shaken the NSA to its core, right? So here's our timeline, right? Before 2012, what was our mindset? Our mindset was, hey, we can prevent these attacks. Let's just download our virus software and do whatever we're doing, and we're good, right? We're good, right? So here in 2012, Robert Mueller, who was then the FBI director, said there are only two types of companies, those that have been hacked and those that will be. And even that's merging into one category, those that have been hacked and will be again. Go forward 2 years, James Comey now, FBI director, right? There are two kinds of big companies in the US, those that have been hacked by the Chinese and those who don't know they've been hacked by the Chinese, right? And so where are we today? They're right. This is a huge problem. We don't even know if we're being hacked. We have moved from I can prevent it to can I tell if I've been hacked, right? How much threat hunting are you doing, right? And does the law obligate you to threat hunt? And I would suggest to you that from several perspectives, I think it does. So here's back to Robert Mueller. Terrorism does remain the FBI's top priority, but in the not too distant future, we anticipate that the cyber threat will pose the greatest threat to our country, right? And that's about 6 years ago. So many of us would agree with that today. So that's the background. So what's the U.S. solution, right? This is the U.S. solution. It is a siloed, sectored solution, right? So we have the Fair Credit Reporting Act, which is really a privacy act and maybe our first privacy act from the 70s, right? We have HIPAA, right? We said, well, let's go deal with medical issues, right? We have GLB, right, for those here who are from the banking side, right, dealing with financial information. And we have 48 state database breach laws. That is our solution. If you think that looks a little disjointed, whatever, that we could talk about that. And even when you look at the sectorial approach, like for HIPAA, you think, okay, well, medical information is protected, right? Well, not really. It's covered entities who are regulated. So if you go to a blood bank and you give blood, they're not a covered entity. Your medical information at a blood bank is not covered by HIPAA. If you swab your saliva and send it off to one of these, genome companies to get your ancestry and all that, that's not a covered entity. All that medical information is not covered by HIPAA, right? So maybe there are some holes, maybe there's some issues with the U.S. approach. So to sort of, these four, or these examples here, aren't the only examples, right? Here is the waterfall of federal statutes, right? We start out with the Fair Credit Reporting Act, And my color scheme here is the black. This is on a privacy scale. So black means it's good for privacy, red means it's not good for privacy. It's not a commentary on whether it's a good law or bad law. It's just judging it from a privacy standpoint, okay? So the Bank Secrecy Act, right, may be good for banks, but not good for privacy advocates, right? The green is California, right? California has been very, very active early on, you know, in the privacy space, so you can't ignore, you know, what's going on in California, right? So we have all these things. So then we say, hey, we better get around in the 80s to start regulating telecom, right? So we get all these specialty statutes on that, because it's our approach, siloed, sectored approach. Driver's Privacy Protection Act. I actually had to deal with that in a transaction. Didn't even know it was there, right? Think of all the data that is collected by every state for every driver, right? So this is a statute that regulates that database, right? Then the blue. What's the blue? The blue is, think the Atlantic Ocean. This is the European Union, right? What's coming across from Europe? So in 1995, Europe says they have a directive, which is not a law. It's a directive that says, privacy, we are going to do something about our concept of privacy as a fundamental right, which is very different than the US approach, right? So then let's keep going. We get HIPAA, right, in 1996. We get, a few years later, we get GLB. We also have the Patriot Act, right, because of the terrible events of September 11th, right, which from a privacy standpoint is sort of a step back. And then I dedicate a statute here to, or the slide here to California, because this is the very first database breach statute in the country, right? So this is California. Now, as presented here, this statute actually shows the updates to the statute in 2007 and 2016. But basically, it's how most state database breach statutes are today. It defines person identifiable information, and it generally excludes, it does exclude encrypted data, right? So if your data is encrypted, you don't have a breach. You may have had a breach, somebody took it, but if they took encrypted data, that's not a breach. That's not a violation of the database breach statute, and you generally don't have to give, you know, any sort of notice. And it's generally, you know, your first name, last name, and then, you know, social security number, driver's license, some kind of account number. It's those sorts of things. California then adds medical information and health insurance information in 2007. And then they start talking about who's got to comply. It's not just the owner. In 2016, it's who's ever maintaining it. So if it's the processor, not just who owns the data. And that's also a European concept. We'll talk about the controller and the processor, the controller being the owner of the data, the processor being who's actually, you know, housing and processing the data, your service provider. And this statute is very HIPAA-ish in that it has flow downs to business associates for those who are familiar with HIPAA or GLB, right? So we get the CAN-SPAN Act. We get 2003, the Online Privacy Protection Act. Why is it that every website has to have a privacy policy? Well, it's because of this statute from California, right? We all have to comply with the denominator that turns out to be California here. This is why you must have a privacy policy and post it. And by the way, the California Attorney General has a very helpful link on their website to talk about, instruct you how to put together a real privacy policy. And the worst way you can put together a privacy policy is just to say, oh, I'm going to go take that other guy's privacy policy. He's got one. Privacy policy is a privacy policy, and just put it on my website. And you do that, that's inviting the FTC to come in and charge you with misrepresentation, because chances are it doesn't do what your business does, right? Let's keep going. We get the Shine the Light Act, which is now California saying, hey, you got to tell us what you're using with the data. Then 2005, this is really saying, more kind of like the GLB and HIPAA, you have to have appropriate policies and organizational and technical in place to really, really try to protect these databases, right? Then here we are, 2006. So Louisiana was pretty much at the vanguard of this, right? It's in purple, right? Mardi Gras. So here we are, Louisiana database breach law. Then we get in 2008 from California, the bodily implanted ID, right? Where you can't, employers can't require that employees put something under their skin. So think if you're, you know, UPS or anybody who's got trucks or whatever, and they just want to monitor where their drivers are. Hey, put this little RFID, you know, under your skin, and we can track where you're going. So California said that's illegal. The High-Tech Act comes on in 2009. This is basically the significant improvements, upgrade, if you want to call it, to HIPAA. And basically what High-Tech says is encrypt. And if you don't encrypt, we're going to fine the heck out of you. There's some other provisions in there, but that's, and it also has the, where they start regulating business associates. But it was mainly about encryption. Let's see. So now here in 2012, we get, again, from across the pond, now the EU says, we got that 1995 directive. We are going to make a law now, and we are going to upgrade this law. We are really going to focus on the digital economy and this real concept of privacy as a fundamental right. California, we get a drone statute, talks about you can have drones, flying into your private space. And then, and this is significant, 2015, California is the first state to enact a right to be forgotten statute. Now, this statute only applies to minors, right? So these are for all the kids who put up all sorts of goofy things on Facebook or Instagram, right? They have to tell Facebook you have to wipe it out. But it's only for when you were a minor. Personally, I remember there are a lot of goofy things I did after I was 18, so I guess I'm glad when I was in my 20s that we didn't have Facebook. So then we get to 2016, where the EU enacts the General Data Protection Regulation. And it goes into effect 73 days from today. Why am I talking about it? Well, we'll see in a minute. Going back to state laws, in 2017, in August, New York Department of Financial Services, so they're regulating financial institutions, they imposed their own cybersecurity regulation, which is basically GLB on steroids. And then we get, and I'm just picking this one, this is Delaware is enhancing their database breach statute, as are a lot of states. They're starting to say, hey, you have to, by mandate, by law, you have to give 1 year free of credit monitoring to people if the Social Security number was breached. A lot of people were doing that anyway, but you see that appearing in the laws now. So May 25th of this year, the EU General Data Protection Regulation will be here. So what's the US doing? Well, not anything, really. Here it is for the last 3 Congresses, and I know this Congress isn't over yet, but I don't think anybody expects Congress to focus on this with all the other things that are going on. So this would have been, the comprehensive federal database breach statute that would have displaced the 48 states. So we'd all know that there's only one place to look to conform and apply and certify for a database breach, right? Because right now, what are you going to do? If your business is in Louisiana, your servers are at Rackspace in some other part of the country, and you got data from citizens in 14 other states. Which database breach statute applies, right? So that's sort of an issue in some of this, right? It'd be nice to have a federal statute that preempted and dealt with it, but we don't. So on to now to the Fair Credit Reporting Act, right, which is our first privacy statute. I'm not going to say much about it, but it really is a misnomer. It's more than just credit, right? It's used for employment, and they collect all sorts of data. And again, this is the US approach to privacy, which is, for the most part, I mean, we have GLB and HIPAA, but for the most part, the Fair Credit Reporting Act is not trying to regulate credit bureaus about what they can collect. They'd already assumed that they had big databases in the 70s. It was trying to say, you got this database, now what can you do with it, right? That's really what it was about. And that's very different than, the European Union model. So there is a private right of action. That's probably what you want. So you can be sued by individuals, but it's not a very plaintiff-friendly statute. I mean, not that there haven't been class actions under the Fair Credit Reporting Act, but it's really not, that plaintiff friendly, because it has to be like not unreasonable. And there's some information here you can read about. We could talk about it at the break. So, and maybe you know, maybe you don't, you know about Equifax, TransUnion, and Experian, but there are all these other, there's another 30 credit bureaus out there, all these specialty credit bureaus. So there's a link there at the bottom to the Consumer Finance Protection Bureau. You can go there and you can look at all these different credit bureaus who may all be collecting data on you. Although if you want to get back at them, every one of those credit bureaus, as a consumer, not speaking to businesses here, every one of us can write every one of those once a year and say, I want a free credit report, and they have to give it to you. All right. So why do I go through these definitions? Because they're very broad. A credit report, it's not just about credit. It's anything about your character, general reputation, personal characteristics, or mode of living. It's very broad, and the definition of a credit reporting agency is also very broad if you're doing this to give out this information. Why am I saying this? Because many of you, or many of your businesses that you assist, may be aggregating data, right? It's what everybody's doing today, aggregating data, building databases for metrics and analytics, right? Well, watch out, because if you're collecting all that data, and if it's business data, cool. But if it has some personally identifiable information in it, well, you don't want to end up like Spokio, right? Spokio, if you're familiar with that, some students at Stanford, all their friends are in all these different social medias. They say, let's aggregate all this so we all know what all of us are doing. So they come up with Spokio, and they spoke, right? Bring it all in, they aggregate all this. And then they realize that people want to buy. Employers want to subscribe to the information, start using that database to check out employment candidates, right? And then all of a sudden in 2010, in their terms of service, they say, we're not a credit reporting agency, right? Well, it's a little too late. They are, because they're doing it. You don't have to declare to be, and you can't disclaim that you're a credit reporting agency. If you're doing those things in that definition, you are a credit reporting agency. You come under the jurisdiction of the FTC, and as Spokio did in 2012, they had to sign a consent decree with the FTC, $800,000 fine, and they are now under the thumb of the FTC for 20 years. And that's how the FTC works. They put you under 20-year consent decrees, and they are in your backyard, and you're reporting to them, and you have to comply. So this is what Spokio now says. Don't use it for credit. Don't use it for insurance. Don't use it for employee, right? You're not supposed to be doing any of that. All right, moving on to HIPAA. Just a couple of slides on HIPAA, right? Who's the enforcer here? The Office of Civil Rights at HHS. There's a security rule and a privacy rule, extensive risk assessments, implement and test your plan, right? Doing risk assessments, real risk assessments. That's what this requires. You need a security officer and a privacy officer. It can be the same person. It's about what's called protected health information. So that's, personally identifiable information that has this health component to it. I talked about high tech, right? That's the encryption. That's the safe harbor. So if there's a breach of secure personal health information or public health records, well, then you're okay. And the enforcer for those records is the FTC. And they also, believe it or not, the FTC also enforces deceptive HIPAA authorization. So it's not just OCR that's enforcing HIPAA in that sense that that's how they do it, the FTC, under their deceptive authority, deceptive and misrepresentation authority. So just here's a few examples of, what does OCR do? They have a wall of shame where they list all the cases involving more than 500 people. And here's a couple of examples. Columbia University, their hospital, $4.8 million fine, 6,800 patient records. And I could have chosen a lot of examples, but why am I choosing these? Because this server was personally owned by the physician, and it was improperly configured, right? And so the reason I put this here is they're coming in, they're saying, you guys, meaning, Columbia University and the hospital, you really didn't do your risk assessment. You really didn't, put in the controls to monitor all this IT equipment. Who is touching your patient databases? That's why I put it up here, because that's the risk assessment that everybody, needs to do. Here's the University of Mississippi, right? $2.75 million fine. Right, why do I put this one up? A lot of laptops, a lot of thumb drives stolen. But in this case, what it really leads to, by looking at the laptop that's been stolen, is the data's unencrypted, the Wi-Fi is unencrypted, and they're using generic passwords, right? That's a sore point with the FTC, right? Go back to my slide on the 1.6, whatever it is, 1.4 billion records of the clear text credentials and the silly, goofy passwords that people are still using, right? The FTC doesn't like that. OCR doesn't like that, right? So, now we're moving to GLB, right? Who's the enforcer here? The FTC for the safeguards rule. You may be familiar with GLB on the notice side. You go open up a bank account or whatever, and you get all those notices, and they can use your data for certain things if you agree to all that. How many nobody here who's with the bank, but How many of you ever read your GLB notice when you opened up a bank account? Read the whole thing, right? You don't have to raise your hand. We know the answer, right? How many people really read that, right? And so, but the other part of GLB was the safeguards rule. And this is, you know, at least for the financial services industry, this is saying you must secure confidential, you must ensure security and confidentiality of customer information. You have to anticipate threats, right? That's a theme, right? Anticipate threats and hazards to security and integrity and protect against it. And you must protect against unauthorized access where substantial harm or inconvenience could result, you know, to the customer. So that's GLB, and the statute has the flow down to compel you to use that with your service providers. What's the scope of it? It's non-public personal information about individuals who obtain financial products or services, right? Financial institution is defined very broadly. That's not just banks, it's insurance companies, it's credit card processing, it's almost every CPA firm, you know, especially if you're preparing tax returns, but I think every CPA firm, I know many CPA firms that are GLB, I'm supposed to comply with GLB, not only the notices, but the safeguards rule. Are you doing your risk assessments? Are you doing all that? The big firms are. And by the way, if you're a career counselor mainly focused on placing people in the financial services industry, you are a financial institution, and you have to give GLB notices, and you have to comply with the safeguards rule. So here, as TaxSlayer, this is just 2017, TaxSlayer is hit with a list validation attack. So this is where, how many of you have a password and a username that you use on multiple portals, you know, on the internet, right? You don't have to raise your hands, right? So what happens? Someone hacks one of those, so now they got this collection of that, and they go throw it against this other portal and say, gee, I wonder how many of those are also being used over here and get through, right? So this is a list validation attack. 8,800 records are hit. TaxSlayer, basically, you know, some kind of a tax processing, clearly within financial services. I don't know if they were asleep at the wheel, but they're doing nothing under GLB. They have no written information security program. They're not conducting risk assessments. They're not asking people to use strong passwords. They're just basically not doing anything they're supposed to do, right? And they even say, the FTC says, they don't even have controls to detect when a mass of emails are coming at them or a mass of logins are coming at them, which is what happened in this list credential attack, that you should anticipate that. You should have anticipated that. That's what they're saying. The only way, this is the last note there, the only way that this attack was halted is because TaxSlayer had to impose multi-factor authentication. So after the user put in their password, their username and password, then they got some sort of a separate email or a text message that said, here's a code, and go put this in, and now you can keep going. And why am I saying that? Maybe some of you are doing that in your systems, maybe you're not. But the FTC, if you go to the TaxSlayer, you know, page on the FTC website, FTC asks you, have you considered multi-factor authentication? Is asking the world, have you considered that? Right? And this is how the FTC works, right? They are telegraphing, they are messaging to all of us, this is what we're looking for, this is what we're looking for. And they're going to keep putting these messages out, so later on, when you don't have multi-factor authentication, they're going to say, we've been telling you that for years, and you should really be thinking about it. So let's keep going. GLB, the Venmo, I don't know if you're familiar with this application, but college students use this a lot, right? So you go out with a bunch of your buddies and buy some pizza and sandwiches, and one guy pays, and they say, okay, everybody, give me $10, and they Venmo you, and you settle up on Venmo, which was eventually acquired by PayPal, now owned by PayPal. Well, not only were they not complying with GLB, but they were misrepresenting what they were doing. They were saying that the funds were available, but it turned out the funds really weren't available for another couple days because they were doing security checks. So some of these kids couldn't pay their rent because they didn't have their money, and they were getting complaints, and Venmo wasn't even listening to the complaints, and I'm exaggerating a little, but that's pretty much what was going on. So they had no written comprehensive information security program until years later, right? This is when PayPal sort of gets in there and I think starts to clean them up, but the damage is done from the first 2 or 3 years that they operated. So Venmo, right? What's the rule? What's the solution from the FTC? Under the FTC's thumb for 20-year consent decree, right, and all sorts of compliance criteria. So here's the New York cybersecurity from their state regulatory authorities, right, for financial institutions. As I said, it's sort of like GLB on steroids. It's generally more stringent, much greater specificity for information. They actually have 14 different areas that they talk about. Your chief information security officer must report to the board, right? This is sort of the HIPAA thing, right? Annual penetration testing, limits on data retention. That's a big issue because now, and this is we'll see in the EU, how long do you need to hold that data? Do you really need to hold that data for 10 years? Are you really holding that data forever? Why are you archiving all that data? Can't you get rid of that data, right? So that concept of the limits on the data retention or data storage is built into this, and it's built into the EU. You have to have a written incident response plan, and you have to notify the regulator within 72 hours. Well, that is warp speed for anybody who's been involved in a data breach, right? And by the way, that 72 hours is also in the General Data Protection Regulation that will be here in 73 days. So here's some enforcement from the FTC. Fined 104 million. Lead generation. Why do I put this up there? Because this is the FTC really telegraphing. They seem to be very interested now in lead generation companies. So if you're in that space or your clients are in that space, you might want to watch that. Up promise. I put this up here because, I don't know, they're just goofy. They're already under a consent decree from 2012 because they have a browser that you download, sort of a dashboard thing, and it's collecting all this information that they're not supposed to be collecting. So the FTC pounds them in 2012. Then they put out another version of it and rebrand it, and it basically does the same thing. So the FTC comes back in 2017 and a $500,000 penalty. And now, I highlighted the part at the bottom, right? They have to have a third-party assessment. So whatever they do with their browser, whenever they release their browser, whatever they're doing to it, right, they have to bring in some kind of third party to say, does your browser really comply now technically with what you agreed to under your consent decree? So the Privacy Shield, what is that? Well, that is part of, it's what the United States has worked out with the European Union. This replaces the safe harbor that was in place. And it's a program facilitating the transfer of personal data between companies in the US and companies in the European Union. I'm putting this one up here because 3 companies that are listed here, they said that they had self-certified that they were under the Privacy Shield, but they misrepresented that because they really weren't. So the FTC pounded them last year, and now each of them are under a 20-year consent decree for having misrepresented that. So let's go on to database breach. So here is Wyndham. The Wyndham hotel chain took on the FTC for years and challenged their authority to do all that they're doing in the database breach space. And basically, Wyndham lost or gave up, however you want to think about it. They had 3 separate breaches, a bunch of credit card data, and Wyndham said, the FTC, you really don't have this authority. You're way over your authority. You can't do this. Well, they lost. They're under a 20-year consent decree, right? So, and here's the comment from the FTC chairman, right? Not only provide important protection, but by the court rulings in the case have affirmed the vital role the FTC plays in this important area, meaning we're here and we're not going anywhere. So, and what's the next one? And here it is, to hold companies accountable for failing to safeguard consumer data. It is not only appropriate but critical that the FTC has the ability to take action when companies fail to take reasonable steps to secure sensitive consumer information. They are not waiting on Congress to pass a national database breach law. They are there. They are telling you, just like under GLB and HIPAA, you need to go do this. And if you don't do this, you're on our radar and we're coming after you. So here's my little cartoon, right? This is the FTC. They have a lot of bats. They have the Privacy Shield bat. They've got the Fair Credit Reporting Act back. They got the HIPAA Authorization Deceptive back. They got the GLB bat. They got a lot of bats, and they're not bashful about swinging their bats. So moving on to Louisiana Database Breach Law, right? This is a summary slide, but the most important thing here is that there is a private right of action under the Louisiana Database Breach Law, but it is based on actual damages for failure to timely disclose. And that, you know, depending on where you fall on this, that is a major impediment to really having a right of action, a clear right of action, or a liquidatable action under it. Here's some other parts about it in summary. What's the breach? You know, there's no express timeline, just most expedient time possible without unreasonable delay. There's even some qualifiers on that. If you have a method that you've posted in your information security systems, then you can use that method to report. There have only been 6 reported cases that have even cited the statute. Some of them haven't even gotten to the damages issue, but those that have said, read the statute. It says what it says. Just because you've proven that you've been hacked and that, you know, that this institution let your data be hacked, you can't prove, you can't make the connection, you can't connect the dots between that event and the harm that you've experienced. And so there's yet to be any recovery under the statute in 12 years. You don't even have to give the notice under the Louisiana Database Breach Law if, quote, after reasonable investigation, there is no reasonable likelihood of harm to customers, right? So you don't even, not only are we talking about not a claim for money, but you don't even have to give the notice. The kind of the screwy part here is that there is a regulation, the state attorney general, you have to tell them within 10 days if you have, when you have given notice to all the affected consumers. And when you read that blurb from the AG, the regulation, it makes you wonder, well, I have to give within 10 days that I gave the notice, but if I never gave the notice, if I didn't think I had to give the notice and I'm wrong, do my penalties accrue from the day I was wrong about ever giving the notice, which is $5,000 a day. So it'd be nice if the Attorney General would clarify that, but that's where we are. Okay, other state database breach. Here's a link. If you want to, you can go to that, and it shows you all. It gives you a link to every state database breach law if you care to read them. So what are the trends here? 16 states also address data security procedures, plus you got the New York thing I was talking about. 5 states cover this ID theft prevention. You know, you got to have some kind of, you know, credit monitoring, whatever. Some states require information security program. A lot of the states say, you don't have to have a policy, but if you have a policy and you follow your policy, and the policy at least contemplates being within the time limits that we say for giving notice, if you follow your own policy, you're good. So that's sort of that's the carrot and the stick here, right? They're saying you don't have to have a policy, but if you do, so that motivates, you know, businesses in those states to come up with a written policy, right? 27 states require notification to some sort of a regulator, and most of the states are expanding the definition of PI to include other kind of data, health information, biometric, DNA profile, all sorts of other things. So items to consider, right? An incident response plan, right? Do you have that? Who's in the communication protocol, internal, external? What about considerations of the attorney-client privilege, right? Because a lot of this you want to shield because you don't know what the results are going to be. Are you prepared to work with law enforcement, right? That's something you need to consider. And there's a whole lot of other things that are going to be considered. It's going to be covered later in the day by other presenters. Are you doing tabletop exercises? If not, you should be, right? Other items to consider. Do you now want to retain your, you know, theft prevention, mitigation, you know, providing credit monitoring? Do you want to now retain someone to do that because you're not under duress and maybe you can get a better deal, you can shop it around and just sort of have it there ready? Do you want to retain a forensic firm now? Because remember, if we go back to the foundation of all this is that we can't stop it. At some point, someone's going to be hacked at some point. So do you need a forensic firm, you know, sort of there? Because sometimes it can be hard to find them. Those guys are very busy. Cyber insurance, well, you needed that, you know, yesterday, right? You need to at least consider, do you want to align with and certify for the Privacy Shield so that you can avoid some parts of that I'll talk about. And by the way, I give a link here, and it's this document right here. This is the National Association of Corporate Directors. This is their cyber document, and it really has great questions, great cybersecurity questions for directors to ask management or for management to ask IT, whatever, across the organization. And the best part about it is it's free. You can go download it right now, and it's really a great resource. Why do I put this up there? Because our government actually in 1973 was ahead of the curve. The Department of Health and Education Welfare came up with these 5 guiding principles, which really still are the foundation today of, in particular, how the EU's doing it, and even you see it in our other statutes in our sectorial approach, which there can be no secret database. Now, we're not talking about the NSA here. We're talking about civilian databases. Your data shouldn't be in a database that you don't know about, which is why the FTC lists all of those credit reporting agencies. You should know where your data is. That's the concept. You should have an audit right. I should know what data is in there. You should have there should be a limited use right. You can't use that data for everything, right? I should have a right to correct that data, right? And there has to be some sort of accountability for creating, maintaining, and using that, and also, you know, to take reasonable steps to, you know, to secure it, right? So here comes the EU solution. Privacy is a fundamental right. It's akin to the power, think of our Bill of Rights, right? So Congress can't enact anything that would violate the Bill of Rights. And that's how this fundamental right is in the European Union. It flows down through everything. So they have this General Data Privacy Regulation, the GDPR. It's effective in 73 days. It is the de facto worldwide standard for data privacy. Don't just think of this as a European issue. And I say here, follow the data, and you'll see why in a minute. So this regulates how any company in the world can collect and process the personal identifiable information on Europeans. And I say PII because they have a different approach to defining it. We actually define things. It's sort of the American way. We define, whereas the European approach is contextual. So there could be certain data that maybe it identifies somebody and maybe it doesn't, and you have to sort of look at that. So US companies, this is the important part, are subject to this as to, I call it the nexus, that's not in the statute, in the EU. So it's not just if you have physical plant or offices, and you're probably thinking, how could this possibly apply to me? Well, if you're offering goods or services to data subjects, I'll talk about what that is, in the EU, even if it's free, you are under the GDPR, or if you're monitoring data subjects' behavior, then you're under the GDPR. So what does that mean? So a data subject is certainly an individual, but it could be beyond an individual. You could be collecting a profile. You have a username and a password, but you haven't yet associated with a real person. But that's a data subject. And you have to be, because if it can be one day associated with a real individual, that's the sort of thing you have to worry about. It's just not when finally, it doesn't say if it does, it says can it be associated with an individual in the future. So big fines, up to 220 million euro, or 4% of a company's global revenue, right? So what does that do to your margins? So not good. So let's say that some Europeans come here for Mardi Gras, right? Those transactions, they run around, they spend money at this hotel, they go to our restaurants, they do whatever, right? All those transactions are not covered by the GDPR, right? But, you know, they go to the restaurant and the waiter says, hey, you want an e-receipt for that? Oh, sure, I'll take an e-receipt. Here's my email, you know, and it's this email address that obviously has some country code, you know, the DE for Germany or France or whatever, and you swipe it in. And now you start using that email you just add them to your email list and start blasting things out, and whatever you're blasting out, your emails have the little web beacon pixel in it, right? And so the guy's back in Paris or he's back in London, and you're picking up that data, right? You are now monitoring a data subject who's in the Union. Once the data subject returns to Europe, you know, if data's coming back, that's why I say follow the data. If you see data coming across the Atlantic, you are in the GDPR. So think about how many of your customers, if you're service institutions, right, or retailers, that you have information on Europeans in your database. So given these big fines, what are you going to do, right? Assuming you don't have a physical footprint in Europe, right? Again, I say follow the data, right? So this is comprehensive and uniform regime. It's all about transparency. Here are the rights here. I'm not going to go through them all because I'm running out of time here. But it's specific purpose consent, right? You don't just get a consent for anything. Now, you've seen that in GLB, but it's even more than that. And when the purpose ends, you have to get rid of the data. And the question is, how much data are you collecting that is beyond what you really need? If you're opening up an account for someone, right, and you need certain data to do that, well, that's part of the contractual process, and you can keep that data as long as the account is there. But how much more data do you collect? And it's that data that if they gave you consent for it, they can withdraw the consent at any time. at any time. And so now you have to think about, what data do I really need? This is the data minimization concept. And what data do I really not need? And if they ask me to get rid of it, I got to get rid of it. And if your systems, if you have a lot of legacy systems that are all cobbled together and you got data all over the place, think about that as a logistic. So there are some other exceptions here. By the way, processing is defined very, very broadly. It's collection, recording, So here's the concepts: lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, right? You can only store it for so long. Here are the actual sort of the privacy bill of rights that they have: the right to erasure, the right to correction, right to data portability. That's another thing. They can come to you and say, give me all my data and I want to go take it and give it to somebody else. They have that right. So I'm not going to go through these. It's all here. Here's the right to be forgotten. Oh, the data, here's the 72 hours, right? I'm up on slide 75 now. You have 72 hours, or you better explain why you didn't tell the regulators within 72 hours. But again, encryption. Encryption is your safe harbor here. So what is the privacy shield, right? This is what I call the baby GDPR. I'm not the only one that calls it that. So this is your easy way, sort of, to comply, right? And the main benefit of this is it shifts enforcement from the EU to you-know-who, right, the FTC, right? And you can avoid those big fines. And you have to set up a relationship with an arbitration society, like the American Arbitration Association. There's another 10 of them, and I'm an arbitrator for the AAA, so full disclosure there. But anyway, you set this thing up, and you have to pay for it. So if a European has an issue with whether you did correct the data or didn't correct the data, or you did erase it or you didn't, or there was extenuating circumstances why you couldn't erase it. All those, if you can't solve them, resolve them, in some other forum, then you have to go to arbitration, and the institution has to pay for the arbitration. But the arbitration is not about money. It is about non-monetary relief. It's all about the database. Does the database really reflect the rights of that individual? Are you really complying with the requests and the rights that they have as to that data under the GDPR? So here's some more information on collection. You can self-certify. So it's not an application process. You're not waiting, right? Thank God. You're not waiting for the government to get back to you to approve you. You self-certify. You have to comply with certain information. You have to take your privacy policy and make it much more EU-ish, as I say. You have to talk about which data is subject to the self-certification. You have to say, am I verifying that I'm in compliance, or am I going to hire a third party to come in and verify that I'm in compliance with these EU rules, right? So I say more than 2,500. I think it's up over 3,000 businesses have already self-certified in the program. Here are the costs, right? So you have to, this is the tax, so to speak. If your revenue is 0 to 5 million, it's $250 a year that go into the fund, so we can support this arbitration remedy. And again, this is a deal that's been worked out between our government and the European Union. And by the way, there are a lot of people in the European Union who are saying this isn't enough. This privacy shield doesn't go far enough. And some in the European Union are saying, this is really only temporary, just like the safe harbor turned out to be temporary. So, but right now, if you don't want to be subject to those fines, you really at least need to consider, do you want to self-certify? Here's my takeaway, right? The FTC is not waiting on Congress, right? The GDPR is right around the corner, literally, right? Think about self-certifying for the Privacy Shield. Some states are pushing it, right, for their database breach statutes, California, New York, Delaware. They're not the only ones. And here, maybe this makes you feel better, maybe it doesn't. If you've learned to live with GLB or HIPAA, you really have paid your dues and you're ahead of the game. You really, really are ahead of the game. And if not, no time like now to adopt risk assessment and incident response plans. By the way, not all entities can self-certify under the Privacy Shield. Banks and insurance companies are not under the jurisdiction of the FTC. So if you're not under the jurisdiction of the FTC, you don't even have access to the Privacy Shield, which was the same thing under the Safe Harbor. So there's a lot of community banks and small banks who are really having a difficult time, with the GDPR because they can't opt in. Now maybe they're supposed to expand, other enterprises. There's some discussions going on between the U.S. and that, but that's a problem right now for community banks. So there you are. I'm sure that's exactly what it felt like. I hope the materials are a good reference source for you as you go forward. Thank you.